Yes, sir.
And section 5 I just flagged is the provision under which an expert committee is a separate creature under the act, which has to be constituted.
Section 62.
Please.
Power to make rules.
Now, under section 62, my lords will see the first part authorizes the government to make rules.
Yes.
Second part mandates that in particular and without prejudice to the generality of the foregoing power,
Oh, this one. Yes.
such rules such rules may provide for all or any of the following matters, namely.
Yes.
My lords will notice that in subsection 1, it has to be after consultation with an expert committee.
All right.
Once the rules are made, the expert committee's mandate is necessary. One admission that the state candidly makes, which has troubled the apex court also in a judgment that was passed, was that there is no expert committee at all. And there has been no consultation at all, no data have been collected. The second issue, my lord, comes from Annexure R1 to the objections. My lord, in the state have Annexure R1 to only peruse the manner in which the impugned notification has been brought about.
1 minute. Sir. R1, so the statement of objections.
Please, my lord. It's a letter dated 13th of October 2023.
Objections by whom? State.
Objections by respondent 1 and 3.
1 to 3 state. Yes.
Please,
R1.
R1, page number 8. My lords will see in the very first.
In 1023.
Yes, yes.
Yes.
And my lords will note that the impugned notification is 31/10/23. It's a mere 2 weeks thereafter.
All right.
They invoke section 62 along with rule 45, under which the education assistance is provided for.
Yes.
And there's a tabulation where they say that over in para 1, they say number of years, number of applicants have gone up.
Yes.
And they say in 2022-23, 11,13,000 applications are received, but eligible applications are 9,61,000.
All right.
Therefore, on that basis, now my lords will see para 4 what they say. ಮಂಡಳಿಯ ಪ್ರಸ್ತುತ ಜಾರಿಯಲ್ಲಿರುವ ದರಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ಶೈಕ್ಷಣಿಕ ಧನ ಸಹಾಯ ನೀಡಿದ್ದಲ್ಲಿ ಪ್ರತಿ ವರ್ಷ ಕೇವಲ ಶೈಕ್ಷಣಿಕ ಧನ ಸಹಾಯಕ್ಕಾಗಿ ಮಾತ್ರ ಅಂದಾಜು 1,500 ಕೋಟಿ ರೂಪಾಯಿಗಳು ವಾರ್ಷಿಕವಾಗಿ ಬೇಕಾಗಿರುತ್ತದೆ. My first submission, my lord, is that this figure is absolutely without basis, which is established by their own reports and the CAG report, which I will point out to. The second, my lord, and this is the troubling aspect, there has been no application of mine. And in para 5, what they do is to say that without application of mine, no expert committee, there is no board also. They say we will simply adopt what the social welfare department has notified and we will apply the same for 10 standard, first standard to 10 standard. Matte Snatakotra for anything PUC and degree onwards, we will just double it, which, my lord, is a minuscule sum compared to what is provided under the fund. The most troubling aspect, my lord, is in para 6. My lords, please have it.
Yes.
ಪ್ರಸ್ತುತ ಮಂಡಳಿಯ ಸದಸ್ಯತ್ವವನ್ನು ರದ್ದುಪಡಿಸುವುದರಿಂದ ಮಂಡಳಿಯ ಪುನರ್ರಚಿಸಿದ ನಂತರ ಈ ದರಗಳನ್ವಯ ಘಟನೋತ್ತರ ಅನುಮೋದನೆ ಪಡೆಯಲಾಗುತ್ತದೆ ಎಂಬ ಅಂಶವನ್ನು ತಮ್ಮ ಆದ್ಯ ಗಮನಕ್ಕೆ ತರಲಾಗುತ್ತದೆ.
All right.
The day when this decision was taken, my lord, this is notified. There was no board. There was no expert committee. Merely 2 weeks through the Dasara vacations, a letter is sent, and on 31st of October, with retrospective effect, to impact even students who are already enrolled, the notification is set out.
All right. Yes.
The state does not dispute any of this. In fact, this is their stated case. The troubling aspect comes, my lord, is to justify this move. They suggest that there are no funds available. This, my lord, the CAG has taken a serious view of to say a few things. I will just give the broad heads. First is that there is diversion of funds. Matters that are...
Where do I get that?
I've prepared, my lord, if I may just assist my lords with...
Yes.
I've tried to crunch down all the figures into a few... I'm just handing this over.
You have culled it out from the report, right?
Yes, everything is from their reports.
Yes.
My lords may straight go to the very end, my lord. There is at Annexure G, page number 68.
And you have to, my lord, go through this.
No.
It's all there.
No time. It is culled out from the report.
All from the
Don't
report.
take time at all.
And I've given the page reference.
I'm going to finish this today. Yes.
How do you respond?
My lords
Respond. Why, sir? This is not from the report, you know, sir.
Full.
Everything
no, sir.
is
Everything is from the
all
report,
is
you
from-
know, sir. No, I'm not adjourning it even for a minute. Yes.
And to assist, my lord, both sides have culled out the specific page number from where the data is taken.
Yes.
Page 69, my lords will have. We've culled out of image here. My lords will see in 23-24. Do my lords have it? At page
60?
69.
Yes.
We've depicted the figures in the form of an image graph. My lords will see towards the end in 2023-24.
Uh,
I've put a legend there. In the prior fiscal year, the administrative costs exceeded the educational funding.
21, 22.
23-24, last year, my lords.
Yes, 23, 24.
In fact, my lords had passed one order on a previous occasion saying, let them file a statement saying how much they're spending for administrative purposes.
ಅದು ಹಾಕಿದ್ದೀರಾ affidavit?
Yes.
All right.
I will point out to that affidavit also as to why that those figures they have mentioned are inaccurate or incorrect. Now, my lords may see the next page. KG makes another finding that by mere negligence, which is by not applying for an exemption under section 10, subsection 46 of the IT Act, over 3,000 crores have been spent in unnecessary tax liability. So what has happened, my lord, is that just because an exemption was not applied for, tax liability has accumulated.
Who had to apply?
The board, my lord,
Board,
the state. And thereafter, what happens
Yes.
is that they do not also file their statements on time, as a result of which penal charges are levied. All of this, my lord, is at page 295 of volume 2 of the writ petition.
You have said so in this?
Yes, it's in. This is the CAG report, my lord.
All right. Next.
Now, just to give a, because their entire cases, the funds are not available, what is shown at para 70 is that just by avoidable tax liability, 7 years worth of the program can be run for all the students at the 2021 rates. And even if I double that amount, it can be run without any more, assuming no further cess is collected for 4 years and 9 months. So an argument to say that for a statutory duty funds are not available, my lord, is not a defense that the state can take. And even assuming that there is some weight to say that yes, funds are deficit, that is not the factual scenario. Because even that figure of 1,600 crores is without basis. The next page, my lords will see page 71. This is a representation of the inadmissible and wasteful expenses.
Yes, that I have seen.
Yes. All of this, my lord, is cumulatively more than all the amount ever spent on education. Just the wasteful expenses.
Yes.
And now, my lords will just have page 72 for a minute.
Yes.
My lords will see the number of inadmissible heads under which money is being spent. For example, my lord, there are unauthorized training schemes that are for which money is being doled out to the extent of 745 crores. The CAG has taken issue with this, saying under what head are you spending this money? And are these going to third-party contractors who do not have a place under the scope of the scheme? And to just give two examples, my lord, Manrega government schemes that have nothing to do with the act, Manrega, and also the Indira Canteen scheme is being funded through money that has been collected in under the act. I will only point out the two heads. My lords will see on page 72, from the bottom of the page,
Yes.
there's Manrega related expenses.
7 crores.
Yes, my lord. And Indira Canteen.
That is 18 crores.
These are only two examples, my lord. The list is very long. Even contracts that have been given to Kionics for some software related work.
Goes from this fund?
Yes, it has gone from this fund. The work has not been completed, and the ones that have supposedly been completed have been of no use.
Yes.
And what the CAG notes with some concern is that to overcome the tendering process, works in excess of 10 crores have been broken up into smaller segments of less than 10 crores so that a tender notification does not have to be.
It's all right. That will see.
Yes.
Yes.
Now, my lords, coming to the, so in sum total, what my lords see, my lord, is that the entire argument that 1,600 crores will be needed to fund the project every year if the erstwhile notification is maintained is fallacious for the following reason. The CAG has accounted how much it costs on an average per student to run the scheme. That figure, my lord, that's at annexure AB, AK,
Yes.
and my lords will see at page number 432.
Yes.
My lords will take page 445.
Where is the apex court saying something?
I've also placed the judgment on record.
Yes.
I'll quickly.
Where is that?
My lords may just take page 445.
45 of the petition?
Yes, my lord. 445. This is in volume
445.
Volume 3, annexure AK.
Volume 3.
Yes.
Volume 2. Volume 3. Volume 3. Yes.
Annexure AK.
AA.
AK. A for K for Karnataka.
Yes. Page?
445.
45. No, it's CG.
445.
Please, my lord.
Yes, sir.
My lord, this is the only record with some authenticated numbers. The state has not provided any. This is pertaining to Karnataka. Education, my lords will see average per beneficiary. The cost is 5,261 rupees.
Yes.
My lords may, only for the sake of testing their argument, double it by 50% to take it closer to 7,000 odd. Even then, my lord, the entire program on the notification of 2021, without considering the notification that has now been impugned, is in the range of 500 crores to 700 crores.
Yes.
So the argument that we need 1,600 crores does not hold water. My lord, this is their figures. And to add to this, my lord, in their audit statement, the audit statement that the government has now placed before this court, they have spent less than that amount. They have spent on an average about 2,000 rupees per student, which brings the figure less than 500 crore. So the only argument that has been placed in the objections is to say that we have a budgetary constraint. The budget is capped at 500 crores and we cannot spend more than that. On the first submission, my lord, 500 crores itself may be sufficient. But the second is that even if it were to need more, that is not a defense to say that statutory obligations will not be discharged. The third issue, my lord, that is troubling, and it came up in a previous order of my lords, is the FDs that have accumulated. And the Honorable Supreme Court has also come down heavily on this.
Good.
I will only refer to one order of the Honorable Supreme Court.
Page?
My lords may, it's here. My lords may straight have their, the affidavit filed by R2 on the statement of expenses.
Yes. That is dated 26/7/24.